Good morning and welcome to the Florida Supreme Court. The first case on today's docket is Freed versus the state of Florida. Counsel?
Good morning. May it please the court. Edward Geddes on behalf of the petitioners. With me at counsel table is Nicole. This case presents two fundamental questions for the court. First, whether the Florida Constitution imposes real limitations on the power of the judiciary, or whether the legislature may simply modify those powers when it sees fit. And second, whether representative democracy at the local level is feckless. We respectfully suggest the answer to the first question is that the Florida Constitution imposes unavoidable and inescapable limits on the power of the judiciary. And with respect to the second, that local democracy must be allowed to survive in our cities and our counties, even at the expense of some state legislative frustration. I'll address these two broader questions in the context first of legislative immunity, and secondly, in the governmental function immunity. As a matter of more than 2 centuries of American history and tradition, the judiciary has never had the authority to inquire into the motivations or intentions of individual legislators acting in their legislative capacity. That lies at the heart of legislative immunity. And in fact, this court and the United States Supreme Court have both described this principle as a cornerstone of American democracy. And yet, in this case, the First District's decision endorses the idea that the legislature may expand the constitutionally restricted authority of the judiciary to engage in such an inquiry and hold legislators liable for voting. In Bogan, the Supreme Court unanimously stated, where the officers of a municipal corporation are invested with legislative powers, they are exempt from individual liability for the passage of any ordinance within their authority, and their motives in reference thereto will not be inquired into. If the First District's decision on this point is allowed to stand, if the legislature is allowed to expand or adjust the powers of either of the other branches in order to punish local elected officials, then our 3-branch form of government essentially becomes a single all-powerful branch.
Could I ask you to connect those dots a little bit, because I followed the peroration up until where you said no one can inquire into the motives of these legislators, and then the next sentence is about penalty, not about inquiring into the motives. And as I understand the deliberative privilege, it protects deliberation, not a particular absence of consequence for legislative decision. Can you connect those two dots about why a penalty constitutes an impermissible intrusion into the motives and deliberations of a legislator?
Certainly, Justice Curiel. As Justice Thomas wrote for the U.S. Supreme Court in Bogan in explaining the fundamental necessity for legislative immunity is to preserve the independence of local legislators. Because absent that independence, if with every vote a legislator can be hauled into court and asked, why did you vote the way you voted? What were the facts?
Who's asked that? Where in the statute do we have that inquiry going on? Because I agree that inquiry would be problematic. I'm having a hard time connecting the dots between what the statute says the legislature has given itself the power to seek and that inquiry that you just stated, inquiring into the motives of the legislator. Why is the motive of the legislator relevant?
I agree that it's not relevant, but Section 3C of 790-33 requires that the imposition of a fine, of the penalty, on an individual local legislator be made after the court makes a determination that the violation was knowing or willful. And I'm not quite certain how an individual fine could ever be imposed for knowing and willful conduct without inquiring into the motivations or processes, legislative processes of an individual legislator.
Don't we do that all the time, though? I mean, motive is not an element in a criminal case, right? All we find is
some do, but
okay. But by and large, if we've established that an actus reus was committed with a mens rea, and it was voluntary, that is generally enough to say that the behavior was culpable. I'm not sure. I credit the answer that you've given because it does sort of start to connect the dots. But then the problem is, I don't know that the legislature has contemplated here a freewheeling inquiry into the motivations of the legislators. It has instead just prescribed a penalty for certain acts. And if I'm inclined to agree with you that probing into the motivations and the internal thought processes of the legislature is constitutionally problematic for the separation of powers, I'm not sure how that carries the day. I'm not sure why that's the basket you're putting your eggs into.
Well, in this particular, the legislature chose the language it chose. When it created this remedy or penalty, it chose to include some intent component into this. Conceivably, the legislature had simply said, if there's a preemption, any local legislator who voted in favor automatically gets fined.
Well, what about this? And this is, of course, a matter that the parties have briefed extensively, but I'm curious as let's say they cut it all the way down. All county governments are hereby preempted. There shall be no county government, or rather there will be 60 county governments instead of 67. You would agree that the Constitution doesn't stop that, right? And that's not an infringement on the deliberative process of any legislator, right?
If and when the legislature chooses to abolish any particular local government, then obviously the court's going to address the consequences of having done so.
Well, yeah,
but as long as they haven't.
What I'm struggling with is the consequences for your argument, right? Your argument is that it is an infringement on these legislative prerogatives securing the separation of powers that the legislature not adopt these penalties. And what I'm saying to you is, if you concede that the ultimate penalty, abolishment of the local government, would not require an inquiry into the motives of anyone and is constitutionally permissible, isn't that a real problem for your argument?
I don't think so, Your Honor, because it creates two different problems, admittedly. The abolishment of a particular local government creates its own set of problems. But if you're going to have a local form of government where the citizens of Florida vote with the expectation that their vote has some democratic consequence because they are electing individuals to represent their interests, and the Florida Constitution confers on those individuals legislative power to perform their duties, then to pull the rug out, so to speak, from those local legislators by saying, well, you can do that, but if you do that and we don't agree with you, or if you take a position that we've determined is not a permissible one, then we're going to punish you individually just for how you voted. And in a completely different way, that undermines democracy.
Well, but our Constitution says that with respect to municipalities, that the municipalities may exercise any power for municipal purposes except as otherwise provided by law.
Correct, Your Honor.
I mean, and our cases are very clear about the superiority of legislative power in this arena. Am I wrong about that?
You are not wrong, Chief Justice Kennedy.
And so that's why this whole case is kind of mystifying to me, because underlying what the legislature has done is this express constitutional provision.
We have never disputed.
Well, it would be hard to dispute it.
Well, and we have never disputed it, Your Honor, that the legislature has the ultimate ability to preempt a substantive area of the law. But it goes farther than that in this instance, because obviously the legislature isn't saying simply don't legislate in this field. Don't legislate with respect to firearms and ammunition because we've preempted it and you can't enact that. We get that. But then what happens is, in a scenario such as this statute, where in fact Section 790.33 opens the door to local legislators to legislate in certain areas relating to firearms, and then it says, well, if you do so, and by the way, you didn't do it right, elected official, we're going to punish you. We're going to punish you with a fine that targets you individually, that takes away your ability to have your defense paid for by the local government, that exposes you, and essentially says, don't you dare vote. Even though the statute says you may, and the Constitution says you may, don't you dare vote. And historically, Your Honor, as you know, this issue comes up many, many times. The remedy for a preempted ordinance is a legal action to declare it preempted, unconstitutional, and unenforceable. But this goes a step further. And it says if you voted knowingly or willfully, whatever that may mean, then there are additional consequences to mere preemption. There are punishments. And that's where I think the problem transgresses. No question. There is no question. Underlying all of this is the notion of the preeminence of the state legislature to preempt substantive areas of law. We don't dispute that. But this is a legislative fire hose to put out a birthday candle.
But aren't we talking about here the legislature's ability to change substantive law?
Correct. And
I mean, that's completely vested in the legislature.
And they have, and they've changed the substantive law.
And a governmental immunity or legislative immunity, whichever, is a substantive law issue, correct?
I don't believe so. Legislative immunity.
It derives from the common law. The immunities that you've cited derive from the common law.
The legislative immunity historically has derived from the common law. But in the state of Florida, it is also tethered to the Constitution by virtue of the conference of legislative powers on
Yeah, but as the case law says, the Constitution confers a legislative power in the state legislature. It's very clear in our case to say that. Right,
but they coexist. You don't, I mean, the legislature doesn't get to ignore one to achieve another one, to comply with another one. You can't just suddenly say you're going to be a legislator, a local legislator, but you're not going to have any, but you can't legislate, or you have no immunities for engaging in legislation. That's where the problem lies. I'm trying to hypothesize a scenario where it's not problematic, but the idea that you can have constitutional authority to legislate and not be protected by legislative immunity is contrary, it's certainly contrary to Bogan. That's what the U.S. Supreme Court said in Bogan. If you've got that power, then you have legislative immunity. So if the legislature wants to undo that and have greater control over legislators at the local level, well, they can go through the process of amending the Constitution. They can take away that provision of the Constitution that says that you have legislative powers and put it in a statute over which they have plenary control.
Which provision are you talking about? Exactly?
Article 8, Sections 1 and 2, that give express legislative powers to local legislators. Now, that's a structure, and this is what the trial court originally concluded, that constitutional structure is beyond the power of the legislature to change through a statute. There may be other mechanisms, but through a statute, they can't alter it.
Article 8, Section what?
Article 8, Section 1, which deals with counties, and Article 8, Section 2, which deals with municipalities.
The only section in Article 8 that I see that specifically addresses this is in Section 5B, where it says each county shall have the authority to require a criminal history records check and a 3 to 5 day waiting period.
As to gun-related issues, yes. I'm speaking more broadly as to the structure of county government and the structure of municipal government.
That specific issue, the trial court held that it was no problem, had no problem with a conflict with the statute, held
Correct.
it to be valid, and this appeal relates to that specific provision, not at all, right?
Correct, because that's the trial court correctly concluded. It's in the Constitution. The state didn't dispute that issue, didn't appeal that, any ruling on that. So that's not here. That's not before this court.
Okay.
Well, I see I have 4 minutes. Let me turn briefly to governmental function immunity. For decades, this court has recognized that local governments enjoy immunity from liability for certain decisions that constitute fundamental discretionary functions of governance at the local level. And in fact, the state has conceded, has acknowledged that that immunity is a non-waivable one. And that was the court's ruling in commercial carrier, that notwithstanding 768-28, which doesn't address this, there were certain fundamental governance decisions that were beyond the scope of the judiciary to review. And there is no more quintessential discretionary function than the enactment of legislation. And the statute itself imposes under Section 3F liability for the mere promulgation of legislation.
Doesn't that argument prove too much? Because what you've said just now is that there's no more central function than the passage of legislation. Okay. The passage of any legislation? Or, I mean, isn't the narrower question posed by this case the passage of legislation in a field that the legislature has purported expressly to occupy? Like, that doesn't seem to be a core function. I would agree with you that a core function of my municipal government is to pass zoning ordinances or hygiene ordinances or speeding or whatever. Those are things that I think commonly people expect their municipalities to do. How is it a core municipal function to occupy a field that the state has expressly stated that it means to preempt? How is that a core city function?
Okay. There are two components to the answer to your question, Justice Carrillo. The first one turns on the four-part commercial carrier test, the four-prong test. And the fourth prong, which is the only prong that the parties are in disagreement about, is the question of whether or not the act or omission or decision in question is within the authority of the individual or entity that made it or took the action. And the state posits that the question should be asked in terms that assumes the answer, which is, in other words, do you have the authority to enact an ordinance that's preempted? If you ask the question that way, the answer will always be no. If you presuppose the negative into the question, it becomes a meaningless test. And in fact, if you look at the history of this court and how it has applied that four-part test and the fourth prong, it has elevated the question to a much higher level. In other words, do local governments have the authority to enact ordinances, to enact legislation? And the state concedes, obviously they do. So we can't really abide by the four-part test in commercial carrier and ask the question the way you've suggested, Your Honor. That's because it assumes the answer. It assumes the answer.
Well, okay, so let's try not assuming the answer. The city of Coral Gables, where I live, or the city of Key Largo, decides that it's going to pass a local ordinance funding military aid to Ukraine. And the federal government says, that's kind of outside your scope, Coral Gables, Key Largo. Thanks, but you have no power to appropriate. I haven't presupposed an answer, but what I'm trying to get an answer to is that's not a core legislative, that's not a core municipal function. And we're able to discern that it's not a core municipal function because of the subject matter of the law, right?
Let me see if I can narrow it. First of all, with respect to the example that you gave of the federal government, frankly, doesn't care about the dynamics of local government
So pick another preempted state
so
issue, anyone you want.
I'm going to proffer an example.
Go ahead.
790-33 specifically creates an exemption that allows a local government to enact zoning ordinances. All right? Let's assume Coral Gables, to pick your hometown, enacts an ordinance that says there shall be no gun sales, no gun shops, there'll be no gun ranges, there'll be nothing within 500 feet of a school. And along with gun sales, they also have, there will be no liquor sales, they will have, there are a number of other businesses that are excluded from within that zone. All right? It's specifically contemplated that the local government can legislate in that field. It is, by virtue of that fact, it is a discretionary decision to decide to enact that legislation. But if that ordinance is enacted and somebody challenges the ordinance and it is subsequently found to be preempted because somehow there's evidence that the design or purpose of the ordinance was to restrict sales or interfere with gun ownership or something like that, then it's automatic. You're automatically exposed to damages for a wholly discretionary function.
I'll let you keep going.
And I apologize, Your Honor. I've gone over my time.
You have exhausted all your time.
I have.
I will nonetheless afford you 4 minutes for rebuttal.
I actually exhausted my 20, not just the 16. I apologize, Your Honor. Thank you.
Mr. Chief Justice, and may it please the court, I'll start with legislative immunity, which plaintiffs argue is not a common law defense, but a constitutional rule that bars the legislature from enforcing its preemption statutes by holding local officials accountable, even where they knowingly and willfully enact preempted ordinances. The starting point of this analysis is that unlike Congress, which is a government of enumerated powers, the state legislature has the authority to legislate in any area not prohibited to it, like speech or religion. So it's plaintiff's burden to identify a provision of the Constitution that restricts the legislature's power to adopt penalties like this, and there simply isn't one. Plaintiffs first point to Article 8 of the Constitution for its grant of default home rule powers to local officials, and they couple that with U.S. Supreme Court decisions that emphasize the importance of the immunity for those who exercise legislative power. But plaintiffs have it backward. Their lead case, Bogan versus Scott Harris, holds only that Congress intended in the enactment of Section 1983 to maintain common law immunity. In 790-33, by contrast, the legislature clearly abrogated the immunity by creating penalties for officials who enact a preempted ordinance. And against that backdrop, the fact that Article 8 by default gives local governments some form of legislative power simply puts those officials in the same position as the local officials in Bogan, which is to say they have this common law immunity, but it can be taken away by a higher power here, the state legislature. And really, to the extent that Article 8 speaks to this issue at all, it does so by establishing a constitutional hierarchy. It says that local officials have only those powers that are not inconsistent with general law, meaning they're subject to the plenary control of the legislature. And with that hierarchy established, there's no reason the legislature wouldn't be able to provide penalties for its statute, just like any other statute. They've also pointed to this court's decision of League of Women Voters, but that case simply recognizes a parallel between the United States Constitution and the Florida Constitution, which is that just as the speech or debate clause clothes members of Congress with immunity for their legislative acts, Article 2, Section 3 of Florida's Constitution clothes members of the Florida Legislature for their acts. The case says nothing about local officials, of course, because Article 2, Section 3 requires the separation of powers only between the branches of state government. Now, as I understand Mr. Geddes' argument on this point, it's that Article 2, Section 3 limits each branch only to its assigned powers, and that's of course correct, meaning the judiciary may exercise only powers that are judicial in nature. The problem with the argument is that legislative immunity is not a question of judicial power. It's a traditional defense. Among other things, it's well established that it's waivable. It doesn't go to the court's subject matter jurisdiction. I mean, you can contrast that with the political question doctrine, which I'll get to in a minute. You know, in the Citizens for Strong Schools case, it was outside the scope of the judicial power to determine the adequacy of a particular level of appropriation because that's just a toolkit that the courts don't have. We just don't have the same thing with legislative immunity because determining intent and damages are traditional judicial functions.
How does the knowing and willful provision work in practice? How would it?
Yeah, so Your Honor, we interpret the statute to limit the fines provision at least to just those officials who know the ordinance they enact would be preempted, which we take to mean a substantial degree of certainty that it would be. And turning to discretionary function immunity, this court was clear in Wallace v. Dean that Florida's discretionary function immunity doctrine was just an application of the political question doctrine as applied in common law tort cases. We're not challenging anything about Wallace. The discretionary function framework may well operate properly in common law tort cases. We're simply asking the court to make clear that it doesn't stand in the way of statutory enforcement actions like preemption suits. Whether we call this discretionary function immunity or political question, the key point is that common law tort suits allege unreasonableness and preemption suits like this do not. To illustrate the point, consider a plaintiff who sues in tort because he's injured due to a negligently installed traffic light. This is the stuff of traditional discretionary function immunity. The fact finder can assess negligence without a problem in a case like that because there's a standard of care for how to install a traffic light. But contrast that with an example where there is no traffic light at all, and the allegation is that the state was negligent for not appropriating money to pay for one, right? So in that case, the court would have no standard for an appropriation, right? So that's basically the Citizens for Strong Schools case, right? Now contrast that in turn with 790-33. The preemption provision supplies the judicially manageable standard. The court doesn't have to second guess whether a challenged ordinance is reasonable as a regulation of firearms. It just has to ask whether it is a regulation of firearms. That's just statutory interpretation, which is a basic judicial question, not a political question.
But are you saying that if you had a statute that explicitly purported to waive or to take away any kind of immunity that a local government would have for a discretionary function, that it would be essentially non-justiciable if someone actually sued under that because of the political questions doctrine?
So I take Your Honor's question you're asking. So if we add the word unreasonable to 790-33, so 790-33 now prohibits only the unreasonable regulation of firearms. Yeah, I think we'd have a very different question, because the court is simply no court is going to have a standard against which to assess whether a firearms regulation is reasonable or not. Right? That's really exactly the same problem there was in the Citizens for Strong Schools case. But that's, of course, not what we have. All we have is a basic preemption statute that asks the court to engage in statutory interpretation, ask whether the ordinance before it is a regulation of firearms and apply some enumerated exceptions. And this is the stuff of quintessential judicial decision making. And really, the fact that statutory interpretation is a basic judicial function is exactly why preemption statutes categorically do not present a political question problem. And I don't actually take plaintiffs to contest that. I think their only beef is with the damages remedy. And that fares no better because the assessment of damages is also second nature to the courts. court has no questions, I'm happy to rest on our brief.
My friend suggests that courts have always made inquiries into intent and motivation, but respectfully, I don't think courts have ever engaged in examinations of intent or motivation when it comes to legislators. And that's the gist of our Article 2, Section 3 argument as to legislative immunity, which is that if the legislature wants to create a remedy, it can't do so by thrusting the judiciary into a scenario where it is hauling legislators into court and asking them why they voted. Did you know? What did you think was going to happen when you enacted this ordinance? That's where you end up. That's why this particular remedy cannot stand, even if you get past the question of stripping away legislative immunity from constitutionally legislatively authorized bodies.
Well, the notion that in one of these prosecutions that they would be hauled in, but they don't have to testify. The state's got to prove it, right?
I'm not sure how you could ever establish. This is not a criminal penalty, so it's a civil penalty. There's no right of self-incrimination here.
But the burden is still on the plaintiff to prove it, correct?
Correct, and they would get to depose the local elected official and start asking them these questions, and you end up in the exact same place. I don't know how you can avoid that problem. I think that's an inherent defect in this remedy.
It just seems, though, like sorry to interrupt you. It just seems like at the end of the day, it's just you make a very plausible kind of policy argument, but it just doesn't seem like there's any sort of constitutional foundation for what you're talking about.
Well, I think, first of all, our constitutional foundation, admittedly, is Article 8, Sections 1 and 2, and if the court doesn't believe that legislative immunity is inherent in being conferred legislative power, then obviously...
I mean, it just depends. I mean, I don't know if by that you mean it's kind of a baseline against which the legislature would sort of legislate, but if the legislature consciously chooses to take that away in this context, then... you're left with a policy argument.
Well, no, I'm not, because then we get to the secondary argument of whether or not the legislature can, in the process of providing this remedy, expand the power of the judiciary. Because legislative immunity aside, this court has never countenanced the idea that the judiciary may make these kinds of inquiries of legislators. So I have 1 minute, and I apologize, Justice Munoz. I do want to tackle a couple of the comments that were made with respect to governmental function immunity. And it brings me back to the example that I offered to Justice Curiel regarding a zoning ordinance. My friend suggests, well, all the court has to do is go in and make a quick determination as to whether or not it's preempted. Not really. Section 790-33, which authorizes the local government to enact a zoning ordinance so long as it is not designed for the purpose of restricting or prohibiting the sale. That is hardly a non-political question. That is the height of entanglement with the judiciary now coming in and saying, well, let's find out whether or not, what was the reason why you were enacting this zoning ordinance? Was it designed to thwart the sale of gun sales, or was it designed to protect children, from having these vendors within 500 feet? It is not the black and white scenario that the state is suggesting. And lastly, with my remaining 2 seconds, the distinction between tort and statutory remedy, I think, was laid to rest by this court in Wallace. Because in Wallace, as it examined the two-part process, when it asked first, is there a duty of care that exists that triggers the governmental function immunity, the court noted that the duty can arise either from the common law or from a statute. And we respectfully suggest that in this case, this statute creates its duty, creates the standard of what is reasonable. Can you enact this ordinance or not? So we respectfully request that the court quash the decision of the First District Court of Appeal and remand for further proceedings. Thank you for your time.
Thank you, counsel. We thank you both.